I am honored to be here to provide information to our stakeholders in the Midwest and anyone who is taking the time out to share with us today and to learn a little bit about intellectual property basics. The office where I work is the Elijah J. McCoy Midwest Regional United States Patent and Trademark Office. This office opened in July of 2012. It is the first USPTO office located outside of Washington, D.C. Our staff includes on-site patent examiners and administrative patent judges. We serve 9 states, Michigan, of course, as we are housed in the fabulous city of Detroit, and also Illinois, Indiana, Iowa, Kentucky, Minnesota, Missouri, Ohio, and Wisconsin. There are
awesome list.
There are.
We're happy to have you.
Thank you. There are 4 USPTO regional offices throughout the United States, 2 that occupy the Eastern time zone and 1 for each one of the other continental United States time zones. There is an office in Dallas, Texas, an office in Denver, Colorado, and an office in Silicon Valley. So the Denver office opened in July of 2014, and the Silicon Valley and Dallas offices opened in 2015. The United States Patent and Trademark Office has traditionally and historically operated from one central headquarters in Washington, D.C. With the signing of the America Invents Act by President Obama in 2011, the United States Patent and Trademark Office decided to move forward with the establishment of what we then called 3 satellite offices. The first of the new offices opened in Detroit, as I stated, in 2012. Now that you've gotten a slight background on what the patent office is, I'd like to start in on and provide you with an outlook as to what is intellectual property. So intellectual property refers to creations of the mind. Something you create, like an invention or a poem or a song or a sculpture or a logo. Patents, trademarks, copyrights, and trade secrets are all the individual components that make up the various types of intellectual property. Today, I will be focusing in on patents and trademarks. The first topic, trademarks. So you ask, what specifically or what exactly is a trademark? Well, a trademark is any word, name, symbol, device, or any combination of those used to identify the source of products and services. As you can see in the square next to the words that are on the actual presentation, you can see Under Armour. Everybody knows what Under Armour is. The green looking figure for Starbucks, McDonald's, Apple, Macy's, Air Jordan, the American Automobile Association, and Dodge. All of these are identifiable symbols, and when you see them, you understand either the products or the source or the services that are going to be provided by them. So now I'd like to provide you with an overview of IP, sorry for that, an overview of IP trademarks. What is the key purpose of a trademark? Well, a trademark allows customers to identify the source or the producer of different products and services. It helps their buying decision. So when we go to the store and we're buying cereal and we want flakes of corn, well, there are various types of flakes of corn that you could buy. You could buy Kellogg's Corn Flakes, or you could buy the store brand, which would be considered a generic. You know exactly what you're getting when you buy a specific product on a consistent basis. And that is what a trademark is intended to do. Trademarks encourage trademark owners to provide goods and services of a consistent quality and to build goodwill in that trademark. I think I'm on the next slide. There we go. So now I'm moving to the slide below that one. Trademarks find their basis in common law. You can have a product or a service that you are advertising, and you can use the symbol TM next to that name, product, or service that you provide. That means that you have every intention on filing a trademark, or this is a symbol that you would like to represent who you are and what your products are and what your services are. You can register your trademark in a state. So there is a Michigan trademark, an Ohio trademark system where you can register your trademark, and there is federal registration. A trademark is not a business license. Check with your state regarding requirements for business formation. Federally registered trademarks is the next slide, and it's the right to enforce nationally and bring legal action in federal courts to someone who infringes upon your trademark. So I'll give you an example of what that legal action is like. I went to a school, a private school in Washington, D.C., and the name of the school is Howard University. And our symbol is the bison. And everybody knows that a bison is the same as a buffalo. Well, the symbol that we used was also the symbol that is used or was used by the Buffalo Bills. The Buffalo Bills approached us with a cease and desist. You need to not use this symbol for your university, and it was used for a very long time before the Buffalo Bills ever made mention of the fact that they thought that we were infringing on their trademark. And our school had to modify and change the image of the bison that we used in all of our advertising, on our shirts, on any of the things that were related to Howard Bisons or Howard Bison. The Buffalo Bills took ownership and they took action, and they prevented us from being able to use that symbol because it was, in their opinion, leading to confusion with regard to the difference between the Buffalo Bills and Howard University. The use of when you get a federally registered trademark, you have the ability to use the circle R. You are not to use that symbol unless you have a registered trademark. You have the right to record your trademark with customs, meaning no one can ship something into the country or across our borders that bear your trademark or that infringe upon your trademark. It serves as the basis for foreign filing. Many people are now filing trademarks, their US trademarks, in countries such as China and India. Your trademark, once it is registered, will be published in the US trademark database. And when people want to get a trademark, one of the very first things that they do is that they go to the federally registered trademark database to see whether or not that trademark is available. I'm ready for the next slide, which shows examples of trademarks. A trademark can be any word, slogan, symbol, design, or combination of these, including product packaging, product design, and trade dress. A trademark can also be a sound, Aflac, a color, such as the box there that is robin eggs blue, which is the color that is recognized for Tiffany's, the jewelry store. Or it can be a smell. Those slippers that you see there have the smell of bubble gum. They're scented with the smell of bubble gum. So to go back over the images that we have below, the bottle, the actual shape of a Coca-Cola bottle is trademarked. And whenever you see that shape, you know exactly what it is. When you see an iPhone, you know exactly what it is. The same thing with a chocolate kiss. What makes trademark protection special? Federally registered trademarks can last forever as long as they are properly and continuously used. Maintenance documents must be filed timely. So as long as you are using that trademark exists and you are protected. In contrast, patent protection and copyright protections have a limited amount of time associated with the protection that you are able to obtain. I guess at present, I'm not taking questions about trademarks, and I'm not going to take questions about patents until after I have completed going through the presentation. So now I'm ready to move on to a brief discussion about patents. And the first thing that I'd like to discuss is the role of the patent system. The patent system is used to protect inventions. It's used to encourage inventions and innovation. It promotes commercialization and the application of invention, and it also accelerates the commercialization of invention to all of society. An overview of IP. What is a patent? A patent is a property right, and patents language finds its basis actually in real estate or in surveying or in land. Land, which is something that is tangible that you can own. It is the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. It has a limited term, and the term is contingent and based on the type of patent. Patents are territorial. There is no worldwide patent. So you can't file for a patent that's going to provide you protection in multiple countries. Your responsibility is to file in the countries where you believe you require and or need the protection. The government grants the property right in exchange for disclosure of the invention. So disclosure means you're going to put together a patent application or a patent document. The patent document will contain how to make and use that invention, and it will also include a various set of descriptions and drawings and a specification that will outline exactly what the patent represents, or what am I being protected for in my patent. In the next slide, we will see a patent can be used to gain entry into and deter others from entering a market. A great example of that is if you have watched the show Shark Tank. Frequently, when an invention is presented or a product is presented to those who will be bidding on it, they ask the question, well, do you have a patent? And frequently you'll hear people say yes, you'll hear people say no, you will hear people say, I have a patent pending. That means that they have filed an application and they're waiting for the patent office to make a determination as to whether or not they are going to receive a patent. It can be used as a marketing tool to promote unique aspects of a product. So absolutely, the reason why those members on the Shark Tank panel are asking, do you have a patent? Because that document is going to provide you with parameters and boundaries that would allow them to know exactly what they're buying or exactly what they're investing in. It asserts and enforces rights against an infringer or a competitor. Someone can't come along and try to use your invention and to gain monetarily or financially from something that belongs to you. It's used as collateral to obtain funding. Quite frequently, a patent portfolio, when a company is for sale or a company is looking to be acquired, is something that is very attractive to someone who is looking at the company to purchase it, because they would also acquire that portfolio and all of the rights and privileges that are attributed to that portfolio. And it can create revenue, sell or license like other property. If I came up with an invention that other people wanted to use, I could allow them to use my invention, but what I would do is I would license it to them and say, well, I'll let you use this for X number of years at this cost. And as opposed to buying outright or purchasing all of my intellectual property, it might be more expedient or in a company's best interest just to license that aspect of my invention that they need in order for them to be successful. All of these are reasons why people pursue patents. There are various types of patents. There are utility patents, design patents, and plant patents. And the utility patent protects how an invention works, functions, or how it is made. So it can be a process, it can be a machine, it can be an article of manufacture, or it can be a composition of matter. So a process, an example of a process would be a process for removing paint from a building, comprising, and then you would have steps that would delineate exactly what that process includes. A machine could be anything from a small device that's used to actually scrape the paint or to remove the paint from a surface. An article of manufacture, an article of manufacture is actually a means for making something, and a composition of matter, which would actually be something such as the paint that you're removing. Design patents. A design patent protects the way a product or article looks. It's the ornamental expression. So this gorgeous looking office chair here, because of its uniqueness and how it's put together and exactly how it looks, could obtain a design patent, or the designer of this chair could file for a design patent. Design patents can be sought for shoes, such as Air Jordans. They can be sought for cases for iPhones, iPhone protectors, and the like. So design patents, you can get a design patent for a tire simply because of the way that it looks, the tread. So there are various ways to look at what you would like to have protected, and whether or not a utility patent or a design patent would be the best means of protection for what it is that you have invented or what it is that is your invention of the mind. Plant patents are granted for newly asexually produced plants. The term for a plant patent is 20 years from the filing date. So anyone out there working on a blue rose or a purple rose, sitting on that type of invention, since there are very few blue flowers and you've never seen a blue rose unless it has has been painted, being able to grow one would be incredible. Interesting patent examples. I think I would have chosen some very different things, but a mustache guard patented to William Purdy Hellings allows a person to eat and drink without their mustache getting in the way. Not so much of a problem today as it was back when Mr. Hellings was inventing various articles of manufacture. A jewelry brush, patented by Michael Burglass, helps remind children to brush their teeth and looks stylish. Okay. I'd like to move on to a specific type of an application that provides those who are in the process of working towards a patent application or a patent to have additional time to file for their patents or to get their money right or to do some more research. A provisional utility application is filed and it allows 12 months for the person who has filed this provisional application to seek money, to research the individuals who would be utilizing that patent. It allows you 12 months of time before you file your non-provisional utility application. The non-provisional utility application will be examined. The provisional utility application is a placeholder. If you do not file your non-provisional within 12 months, then you are not afforded the opportunity to have that 12-month period serve as a run-up period for your application. You will not have that amount of time, and you can't say that you invented it 12 months earlier to allow yourself some wiggle room with regard to the things that you might need to do with regard to establishing and moving forward in the business. So let's do an overview of IP. So we look at this Apple iPhone, and the trademarks that might be associated with an Apple iPhone include the Apple logo, the apple with the bite out of it, the product that is a part of the phone, iPhone, or the reference to the device as an iPhone with the lowercase i and the uppercase phone, and the software system, which is known as Safari. There are patents on an iPhone for the semiconductor circuits that allow the phone to operate, the touch screen and its applicability and capabilities, the battery power control, how the iPhone actually is powered, the antenna, which allows the iPhone to pick up and receive broadcasts and various other communications, the speaker, which allows you to talk into it and to hear back, and the device housing, the actual casing of the phone, the shape, the thickness, and how it is prepared with the button at the bottom that allows you to move from screen to screen or to actually turn off or turn on. That everything that's connected to and attached to the housing of the device. Copyrights include the software code for the actual iPhone, the instruction manual, which tells you exactly how to use the iPhone, and the ringtones. Various ringtones have copyrights because you hear them only on iPhones. Trade secrets would be just that, secrets. You would not be privy to a trade secret because, shh, it's a secret. Designs, the form or the overall phone and the way that it looks, its appearance. That's what a device, a design patent is directed to. Placement of the button and the speakers on the housing or the actual form, the custom pattern or the trim of the phone, and the surface finish of the phone are all designs that one could obtain a design patent for. I know I moved through all of that pretty quickly, but I'd also like to articulate and to provide you some information with regard to some of the USPTO resources that are available to you. We have outreach services in all of our regional offices and in our headquarters in Alexandria. You may email us, you can call in to us, you can walk in, and there are services that are available to you as they relate to intellectual properties, trademarks, and patents. IP, regionally focused workshops, conferences, and roundtables are held routinely in our headquarters and in all of our regional offices. We have hearing rooms in each of our offices, in all 5 offices, for hosting patent trial and appeal board proceedings with access to hearings held in Alexandria, Virginia, and all regional offices. Trademark trial and appeal board hearings may also be viewed by the public. If you had business before the office, we have interview rooms in our various offices that allow you the opportunity in a non-COVID environment to come into our space and to connect directly with examiners. It allows stakeholders to connect directly with examiners, whether they are trademark examiners or patent examiners. In the Elijah J. McCoy Midwest Regional Office in Detroit, we have a public search room. Whenever you're pursuing intellectual property, you're always advised to do a search to make sure that what you believe you have invented or what you want to obtain protection for is actually available to you. Because if someone else already owns it or someone else already has patented or trademarked the idea that you are now coming up with or you believe that you have come up with, then it's not available to you. So the most important thing that you can do, one of the most important things that you can do, is to come into the patent office and to do what we call a subject matter search. You can search specifically for your invention and the nuances and the specifics and the particulars that make what you believe your invention unique to find out whether or not they actually are. And if you're unable to find them as it relates to a patent search, then you may be eligible for a patent. Likewise, for a trademark, you need to go in and make sure that someone else does not already have the trademark that you are seeking. Now, trademarks are tied directly to the products that they provide or the services that they provide. So a really good example that I like to use to help people out is Dove. Everyone under the sound of my voice, think of a Dove product. Okay, I am sure that some of you thought of soap, and some of you may have considered a chocolate bar. So even though they are both called Dove bars, they both also have the name Dove. But the reason why they can coexist is because one is directed to soap and one is directed to a food type item. And I don't think that you are going to confuse the two. I don't think that you would take a bath with a Dove bar and a Dove chocolate bar. And I don't think that you would eat a Dove soap bar. So the identity is tied to exactly what the product is also. And so those are the types of things that are taken into account when you go in and you do a search. Our patent pro bono program means that you would come into an environment where practitioners or attorneys would volunteer their legal services and their time to provide you with support in seeking to obtain your patent or to obtain your trademark. It assists financially under-resourced independent inventors and small businesses. This is a part of the reason why it's important that you seek protection for those things that you believe that you need to protect for your business, small business or independent inventor. The program is available in every state and is practiced through 23 regional programs. Each regional program endeavors to match inventors and small businesses who apply with patent practitioners who volunteer to file and prosecute their patent applications. So these people are actually going to help you get a patent. But the very important thing that you need to remember in this process is that they have to accept you, and it is a process in which you apply to be a part. If they do not believe that your invention is a real invention or it's something that you could get protection for, they're going to try to save you time and money and let you know that they don't think that this is something that could be patented or trademarked. And yes, there are patent pro bono programs for patents and for trademarks. Another program that we have is the Law School Clinic Certification Program, where there is a practicing intellectual property attorney at a university who supervises the students who are interested in intellectual property in providing you with support and with guidance, and they help you also. So you would also have to apply for these types of programs, but as you can see from the map, there are quite a few of them throughout the United States, and quite a few right here in Michigan, in Ohio, in Indiana, in Illinois, in Minnesota, in Kansas City, I believe, in Iowa, and in Missouri. So these are places, and I don't see one in Kentucky, so I guess there's one in Nashville, I do know, and there's one in Knoxville, which is right across these towns are right across the border from Kentucky. So law school clinic certification programs allow individuals to gain and to obtain the assistance that they need in order to pursue intellectual property. Some have patent and trademark certification programs, and some have only patent or trademark programs. The law school clinic certification program I just reviewed. Patent and trademark resource centers throughout the United States in various libraries and at various universities. There are patent and trademark resource centers, places where you can go and actually perform the search that I mentioned earlier to determine whether or not you've actually invented something, whether or not you actually have a patentable product or a patentable machine or process or article of manufacture or composition of matter, and whether or not your trademark might be free and it's possible for you to register it with the federal government so that you can obtain that protection that I mentioned earlier. Patent and trademark resource centers are scattered throughout the United States. There's another program that's an international program, and it's the USPTO IP Attaché program. This program allows, if you wanted to file in Mexico or Brazil or China, these individuals would provide you with some support, some guidance, and some insight into filing your applications or your application in various countries. And this is a program that is available to U.S. stakeholders. We also have a process for pro se assistance to inventors who do not use an attorney, but seek to acquire their patent on their own. And there are quite a few people who have studied, they've gone to these seminars like I'm giving, they've gone to various talks and various individual programs and have acquired enough knowledge to be able to file their own patent application or file their own trademark application. And as an independent inventor, they have been able to acquire their patent or their trademark. But we have set up in our office individuals who will provide some support and guidance for those who are seeking to prosecute their applications, file for a patent or file for a trademark without the assistance of a registered patent attorney or agent. So the PTO is very proactive in providing assistance for everyone who is desirous of seeking IP protection. I am now going to allow you to ask questions. I'm hoping that I will be able to answer them. If I'm not able to answer them, I'm going to, on the spot, I'm going to provide you with an avenue for submitting your question to me so that I might be able to provide you with the best answer. Matt, are you still there? Martin, are you still there? Sorry.
Yep, I'm still here.
Oh, okay.
Feel free to type questions in the chat. We actually got one. It says, what is your advice for someone who has been granted a patent at a university and wants to transfer it to their company?
They were granted, okay, the question becomes, does the patent belong to the individual? Does the patent belong to the university? If it belongs to the university, then the individual who is desirous of transferring it does not have the right to transfer it. You may be listed as an inventor on a patent, but usually at universities, if you use their resources and you used their legal department to obtain a patent, then 9 times out of 10, that patent belongs to the university. I hope that that's an answer that you can use. If not, do feel free to submit that question to the Midwestern region mailbox at the USPTO. How can I find the pro bono services? The pro bono services, I see someone has written, the pro bono services can be provided. You can go on our website, www.uspto.gov, and you can actually type pro, P-R-O, bono, B-O-N-O, and you will be connected to a link that will provide you with the services that we provide to our stakeholders as they relate to pro bono services. I missed that last one. I saw a patent with question marks.
So it looks like we have a couple questions rolling through. We'll start with Rashida Johnson. Do you see that one?
No, I'm on an iPad and I'm struggling with seeing anything more.
Yeah, no problem. I can read it off to you. It says, if you're not ready to scale up your product yet, should you still pursue a patent?
Absolutely. You should file for protection as soon as someone else might have or take the opportunity to be able to take your invention from you. Our system is now a first to file system. So we are out educating people. You need to keep your invention close to your vest. And it is important that you sign non-disclosure documents with people that you discuss it with, because someone can steal your invention. And I'm saying steal your invention, but if you don't file as expeditiously as you should for an excellent idea, and someone else, a big company or an attorney or somebody else files, and they file your invention, then you will more than likely not have the opportunity to get the protection for the invention that you came up with. I hope that's helpful.
Awesome. Great answer. And then we have one from Todd. Do you see that one, or should I read it off?
Yeah, I do. As an attorney who practices in the trademark work, is it possible to volunteer in the pro bono assistance program? Absolutely. If you go to that website also, I believe that there on that site at the USPTO is a portal that allows you the opportunity to register yourself for pro bono services. So I'm assuming as an attorney, you want to work with someone to help them get a trademark. And yes, that is available to you. If you are unable to find that information on the website under the pro bono assistance link that I've referenced, then please feel free to email me, James O. Wilson, at the Midwestern Region mailbox for the USPTO. Okay. I'm not sure if there are any additional questions.
Yeah, it looks like we actually have a two-part question.
Oh, okay.
It says, is there a way to protect an intellectual property portfolio layout or collection of the way patents work together within a company? In other words, the way that all the patents work together with our partners and the way we operate? That sounds like a company structure, possibly.
Right. I don't see that. I don't see that question. I was hoping for a little bit more clarity. If I apply for a patent trademark, do I need an LLC? No. Would you be so kind as to read that question again? Mark?
Yeah, sure. Let me see if I can actually copy and paste that into the chat, because I'm not sure if I'm reading that entirely correctly.
So one of the things that I'd like to share with everybody is that every month, on the first Thursday of every month, if you go to our website, the Midwest Regional website, or you go to the website and you go to the Detroit office, you can gain access. And if you go to www.uspto.gov/Midwest, you can access monthly programming that we provide. On the first Thursday, it's Intro to Intellectual Property, where we talk about patents, trademarks, copyrights, and trade secrets. And we go into exactly what they are, and we will introduce you to some resources and some tools that might help you make a better decision as to whether or not you need a patent or a trademark or both. On the second Tuesday of every month, we have what's called Trademark Basics, which is an excellent program that is run by our Trademark Assistance Center out of Alexandria. You will get the actual experts from the trademark office to engage you in discussion about your trademark, the potential for you to file for a trademark, and all of your trademark questions. And then every third Wednesday, we have one of three rotating series, one where it is an intro to patents, another one where we talk about the types of applications, patent applications, and the third one where we talk about how to actually search for a patent or search for your invention to make sure that you're not pursuing something that you're not entitled to. So those are programs that we have monthly. This is a one-time discussion or talk that I'm giving, but this is something that we do on a regular basis in our office every month. Okay, so that question, I asked that last week, is there a way to protect an IP portfolio layout or collection of the way patents work together in a company? That's going to be, that's almost, one of the things that I cannot do is to give legal advice. And that borders on and crosses the line over into legal advice. So this is a question that I could not provide you with support or guidance for. If you email us this question, we may be able to provide you with some direction, not legal advice, but some direction as to how you might go about answering the question that you're posing to me right now. I think that's the best way that I can word that. We believe we found a loophole to extend the 20 to 23-year life of our IP by adding claims on an independent claim on the expiring patent and a new patent. Will this work? That's a process that's called evergreening, and the examiners will look at what was previously claimed, what you're claiming now, and make a determination as to whether or not you've actually invented something or whether or not you've only modified it within the realm of what would be obvious to do. And so I can't say whether or not that's a loophole. We do know that that's a process that people try to employ. And I will tell you that 9 times out of 10, it is not successful, because you would need to have invented something new and novel. And if you are only just modifying it, thinking that you're going to be able to extend it, an examiner will probably tell you, no, this will not work and will not be extended. In general, do applicants register in a state or federal first? I'm not so apprised of why someone would file in a state. Usually you file a trademark because you're going to be selling your products or your services across state lines. Okay, so let me give you an example. Rebel Sports, Rebel Cycles. Rebel Cycles could be a place where you go to exercise and everybody rides cycles for exercise. Rebel Cycles could be a bicycle shop where bicycles are sold and repaired, or Rebel Cycles could be a business where motorcycles are sold. So registering that trademark, you would be going up against all of these different Rebel Cycles. Now, it's not just the name, it's also the depiction. So if one has Rebel Cycles and it has a bicycle, and then one has Rebel Cycles and it clearly has a motorcycle, then we don't confuse motorcycles and bicycles because they are not the same thing. So that's probably as loose as I'm going to be with regard to answering that question that way. State or federal, I would file federal. I would file federal. If you're only going to operate within a state, if you're not going to go outside of Michigan, then I would file my trademark for the state. But the federal registration is more than likely the best way to go so that you're protected. And if you're in Michigan, that allows you the opportunity to register your trademark and to prevent people in Canada from seeing your invention and then making whatever it is that you're making cheaper, slapping your name on it and bringing it across the border. I'm going to say if I need to start my application for patent and trademark now. Okay. I am going to, would you do me a favor, Martin, and in the chat, put my email address?
Yeah, sure thing.
Okay. My email address, for those who can write it down right now, is james.wilson, WILSON, and that is at U as in up, S as in Sam, P as in Paul, T as in Thomas, O as in Oliver, .gov. So it's james.wilson at uspto.gov. That's it. Look at you, Martin, you're good. Okay, so if you have any further questions or additional questions that you think I might be able, that I would be able to provide you with some assistance and some guidance and or some direction regarding, as long as they don't cross the line over into a request for legal advice, I will do my best to provide you with an answer, to connect you to a website or a link on our USPTO site that would be able to provide you with the information that you need that would allow you the opportunity to advance your IP desires and your IP endeavors. Martin, are we good? Or are there more questions? I can't see more.
Yeah, there's a few more questions.
Okay.
Whatever you want to do.
No. If there are more questions, I'll answer. I can't see them on my screen.
Oh, okay. Here, I'll read them off too. So one from Helen. Let me see if I can find it. It says, on average, what should my budget be for registering a trademark or trade name?
I'm going to have to apologize and tell you I don't deal with the money. I deal with the granting. On our site is a list of fees, and there are attorneys who you can touch base with. We even have attorneys listed on our website that would allow you the opportunity to get a roundabout figure as to what your budget might be. A patent can be anywhere from, say, $8,000 to $15,000. I don't know about trademarks because I'm a patent expert and not a trademark expert. What else do you have?
All right. And this one says, I'm starting an online business and app, and I'm having a hard time understanding if I need to start my application for patent and trademark now, or if I should obtain the LLC first and work on my patent and trademark later. I spoke with someone about the trademark that's quoted me around $900, but so the LLC would be faster and cheaper.
That's probably bordering on the type of advice that I can't get. I can't tell you how to spend your money, and I can't tell you what's going to be the best course of action for you in your business. I'm sorry.
And we have another that says, the premise of this question is around the timing of the patent application. I only have an idea. I want to build the prototype, or should I wait? I think they're basically asking if you should prototype first or patent that and then build the prototype.
One of the things that patent examiners are looking for is what we call reduction to practice. We like to make sure that something actually will work and is an invention. So what I would say to you is that it would not hurt. It depends on how much time you're working with. The provisional application allows you 12 months before you have to file for your application that is going to be examined by the patent office. So if you file and you give yourself 12 months, would you be able to build your prototype in that 12 months do the research for your potential pool of clients and customers, and would you be able to determine whether or not someone would be interested in investing so that you could move forward? You could file your application early and then take that 12 months before you file your actual application. But first and foremost, my recommendation to you is to do a search and make sure that your invention is not one that someone has already patented. So even before you do your prototype, go to a location, whether it's a PTRC, Patent and Trademark Resource Center, or whether it's to an office, or even online, Google patents, and look to see whether or not someone has invented exactly what you believe you've invented. And if you're not able to find it, then you may be on the right track towards securing intellectual property for something that you've invented.
We have a question from Ryan that says, how do you know if an idea is patentable? Is there a framework or set of questions that we can use to determine the viability of an idea?
The best way to find out if something is patentable is to take it to an attorney. We encourage everybody to secure the assistance of a patent attorney if you're able to. They will be the ones who will help you determine whether or not something is patentable. The idea of whether or not something is patentable is why we have 4,000 examiners. The examiners have to go through the process of making that determination. So when your application is before them, examiners have what we call ordinary skill in the art. And their ordinary skill is usually sufficient enough to allow them to make the determination as to whether or not your invention is patentable enough or not. So the assistance of an attorney or the assistance of a patent agent to help you make the determination as to whether or not that's what you need to do is the direction that I will point you in with regard to how would I know my idea is patentable.
Sure. And if you don't mind, I'd be happy to chime in about the viability of an idea. Regarding Ryan's question, I would recommend interviewing your customers, getting to know who wants your product, who would be using it.
Who could benefit from it.
Interviewing your customers might be a good way to determine the viability of that.
Yeah. As I stated, we have these presentations monthly. Please feel free to join one of these. They're normally at lunchtime, around 12:30 on the dates that I articulated, the Thursdays, the Tuesdays, the Wednesdays, the first Thursday, second Tuesday, and third Wednesday. And if you're able to log on and to register, log on and to partake in these, you're able to ask more questions, and we have more people online who are available to provide you with the answers to your questions. We are at the top of the hour.
Yeah, so it looks like it's all the questions. I want to thank you again for coming out and explaining all of this. Thank you for everyone for attending as well. We really appreciate you coming out for Detroit Startup Week. Again, these are all free events, and we really appreciate you coming out. So thank you again.
Thank you for your assistance in getting me up and running. And anyone who has further questions and would like to have a more dialogue regarding this topic, please feel free to email me, and I'll do my best to direct you and or to provide you with someone who can provide you with some level of assistance. Thank you so much. Everybody stay safe and have a great day.